Good morning, everyone. It is Sunday, November 23rd, and I'm Wendy, and this is Truly Sinister, and I thank you for joining me today. Today, we're just going to go over last week at a glance. I tried to do, I think, one or two lives to go over Karen Reed's civil suit filing against the McAlberts, or quote unquote the House defendants, as she referred to them. And the first one, I found out there was no audio at all, even though there was audio when I went on. I don't know what happened to it. Obviously, I hit something. And the second one had audio through part of it. I was doing fine, and then all of a sudden the audio stopped. So then I tried to do a couple of pre-recorded about her filing, and no audio. So I had to go through a whole bunch of, I was going to quit completely, like take my channel down and throw in the towel. But I decided, well, we'll give it another shot. I just won't cover Karen Reed's filing. Okay, maybe there's an omen there that I'm not supposed to go over that for some reason. I don't know. So today we're going to go over the prosecution's response to Aaron Spencer's brief, and we're going to go over Kelsey Fitzsimmons. There's a new brief on her docket by the Commonwealth about suddenly all of a sudden they're changing their mind and don't want her released on bail. I don't know what changed their mind, and I don't know who got to them or what, but now they're going to play this game, and it was already denied, the moving the hearing up to, moving the decision up to November 21st was denied. It stands at December 3rd, which is complete bullshit. But yeah, so there's some fuckery going on in the Kelsey Fitzsimmons case, and I don't think she's going to make it home for Thanksgiving, and it breaks my heart. So everybody needs to reach out to her, send her letters, cards, and let her know that we're thinking about her, we love her, and we're here for her, and we ain't got no quit. We're not going to give up on her, so she needs to not give up on herself, okay? It's horrendous what's going on with her. So that being said, we are going to start, I believe, with the Kelsey Fitzsimmons brief by the prosecution or the Commonwealth. So here, I hope you guys liked my intro, by the way. I finally got it to work. So what do you guys think? Not bad for a rookie? I'm so proud of that. I made that like over a year ago when I was first going to start a new channel, and I chickened out. So I kept it just in case. So anyway, I was just bragging on myself. Sorry. So now we're going to cover the Kelsey Fitzsimmons brief that was filed by the Commonwealth. Let me make it bigger for you guys, because I know I wouldn't be able to read it if it were me. So, let's see. I don't know why it's doing that. Made it smaller. Okay. Let's. Maybe I can make it bigger on here. Okay, let me get my highlighter. Okay, so are you guys ready? Fingers crossed that this all goes seamlessly, you know? Commonwealth of Massachusetts, Supreme Judicial Court, Essex County, or Essex Superior Court. And that's is that in Salem? That's in Salem, right? So, okay. The Commonwealth Appellee v. Kelsey Fitzsimmons Appellant on appeal from an order of the single justice of Supreme Judicial Court. Make sure I'm unmuted. Brief for the Commonwealth. For the Commonwealth, Paul Tucker, Martina Moriarty, November, and it doesn't have a date, it just says November 2025, which I think is weird. Table of contents, table of authorities, issue presented, statement of the case, procedural history, statement of the facts, A, statement of the facts before J. McCarthy, B, Superior Court 58A hearing, C, motion to reconsider, D, petition for relief pursuant to general law. Argument. Judge McCarthy did not abuse her discretion or commit an error of law in finding the defendant dangerous and mandating conditions of release, where she appropriately considered the defendant's actions in pointing a officer and pulling the trigger, coupled with an admitted history of mental illness and persistent alcohol abuse. I don't know where they keep getting this persistent alcohol abuse. The only time alcohol came into play was that weekend, their bachelorette and bachelor combined weekend, where she was drunk apparently and hit him. That's the only time alcohol has been an issue, and yet they keep bringing up alcohol abuse, and I'm not sure where that's coming from, but it's so freaking annoying. They're making her out to be an alkie, and she wasn't. She was breastfeeding, for crying out loud. I mean, come on. A, Judge McCarthy appropriately weighed the necessary factors when finding the defendant dangerous. The finding of dangerousness, the SCRAM condition of release, the motion to remove the SCRAM condition. Conclusion, addendum, Rule 16, certification, and certificate of service. And then this is all the authorities that they listed, all the case law, I believe, and the statutes, rules, and other authorities. So I don't know what all that is. That's where Melanie Little can help you more than I can. Okay? Issue presented. Judge McCarthy did not abuse her discretion or commit an error of law in finding the defendant dangerous and mandating conditions of release, where she appropriately considered the defendant's actions in pointing a loaded firearm at a fellow police officer and pulling the trigger, coupled with an admitted history of mental illness and persistent alcohol abuse. Statement of case, footnote 1. I keep saying booknote. Record references are as follows: defendant's brief by page, Record Appendix Volume 1 by page, Record Appendix Volume 2 by page, R2, and Supplemental Record Appendix by page. I don't know what any of that means. The defendant, Kelsey Fitzsimmons, brings an appeal from a denial of her petition to a single justice pursuant to General Law C-211. Appealing an order of the Superior Court finding her dangerous and detaining her prior to trial. pursuant to General Law 276. The defendant was indicted on August 25th, 2025, for one count of assault with a dangerous weapon. Yeah, the grand jury didn't indict on murder or attempted murder or anything else. They indicted only on assault with a dangerous weapon. So, and they say you can indict a ham sandwich. So what happened to the ham sandwich? Obviously you don't have a case for murder or attempted murder. But the judge sure is treating her like one, isn't she? What happened to innocent until proven guilty, Your Honor? Although there is no indication that the defendant was intoxicated when she pointed her gun at a fellow police officer, exactly, she wasn't, who was at her home serving a restraining order, the Commonwealth demonstrated that alcohol fueled the precipitating violence in this case and has been a persistent issue for the defendant. I haven't heard anything other than the Bachelorette Bachelor Weekend stating anything about alcohol. That's the only time I've heard alcohol mentioned. So what are they talking about? Why are they trying to make an issue where there isn't one? You know what I mean? So anyway, sorry about that. Recognizing the dangers inherent in the intersection of alcohol abuse and mental health issues, the Superior Court Judge McCarthy J. fashioned reasonable terms of release, including the condition of submission to a scram device that would deter the defendant from consuming alcohol. Despite having obtained her release from custody, within 48 hours, the defendant was back before the court reporting that she was unable to abide by the scram conditions. Therefore, the court reasonably concluded that the only way to assure the safety of the community was to place the defendant in custody. Bullshit. They make it sound like, oh, she doesn't complain and want to change the release precursors. But, excuse me, it wasn't that she to abide by them or was unable to abide by the scram testing. She was in pain. So if there was something else that she could do, then she wanted to do that. But she would have kept doing the scram testing if she knew that that was her only option. Procedural history. A complaint issued on July 3rd, 2025, charging the defendant with assault with intent to murder, General Law C-265. Now, why are they allowed to bring that into it? Because they didn't find anything about attempted murder or intent to murder. All they indicted on was assault with a dangerous weapon. So how are they allowed to bring this into their brief, I wonder? And 2 counts of assault with a dangerous weapon, GLC-265. The defendant was arraigned on August 7th, 2025, and after a hearing was held pursuant to GL 58A. Let's see. I'm going to try something here, so just bear with me, okay? Okay, that should be better now. The defendant appealed the determination of dangerousness to Superior Court, and on August 14th, 2025, the court, McCarthy J., conducted an evidentiary hearing. One day later, Judge McCarthy issued a decision upholding the finding of dangerousness and the conclusion that there were no conditions of release that could safely permit the defendant's release. Notably, the court found that it, quote, has not been presented with a satisfactory release plan, end quote, which is not true. Timothy Bradel, Mr. Bradel, Kelsey's lawyer, said she's willing to go for urine testing 4 times a day. There's an ankle monitor that tests the sweat continuously. There are other things she could have done other than deep breathing, and Timothy Bradel brought those up in court. She just cut him off and walked off the bench while he was mid-argument. On August 18, 2025, the defendant filed a, quote, renewed Superior Court bail appeal with comprehensive release plan for reconsideration, end quote, which the court denied on August 25th, 2025. That same day, the defendant was indicted for assault with a dangerous weapon, the grand jury having returned a no bill on the proposed indictment charging armed assault with intent to murder. The defendant was arraigned, and the Commonwealth filed another motion for detention pursuant to General Law 276. The court held a lengthy hearing on August 28, 2025, after which Judge McCarthy found the defendant dangerous but concluded that she could be released with conditions, including GPS monitoring with home confinement, except for medical and legal appointments with 48 hours notice to the probation, and no use of alcohol with monitoring by a Scram device. The defendant's release was stayed pending a satisfactory home visit by probation. The defendant did not appeal. When probation returned an unsatisfactory result, which was unbelievable, I mean, everybody makes bail. The court held another hearing on November 8th, 2025, at which point the issue was resolved and the defendant released. Before the November 8th hearing ended, the defendant requested that the GPS condition be lifted the following day to allow her to undergo a medical procedure. She didn't ask for it to be lifted. She asked if they could postpone it a day. They could postpone it being applied for a day because, and it wasn't a medical procedure, it was surgery. She needed surgery again. And you can't go into surgery with a GPS monitoring device on you. You can't even go into surgery with nail polish on. And the judge denied it. So she wasn't asking for it to be lifted. She just wanted to put it on after surgery. So she had to cancel her surgery. However, the defendant submitted no evidence in support of her motion, and the motion was denied. 2 days later, the defendant filed an, quote-unquote, emergency motion for immediate relief from Scram order, supported by affidavits from the defendant and her mother, and with an accompanying email from the probation department. Not just the probation department, the boss of the probation department. Judge McCarthy held another hearing on September 11, 2025, where a probation officer testified about the Scram procedure and the defendant's apparent difficulty breathing deeply. At the conclusion of the hearing, the court removed the Scram requirement because she did not want to, quote-unquote, torture the defendant and remanded her to custody. Before the court could issue its 5-page written order later that day, the defendant filed a motion to reconsider. The court denied the motion to reconsider in an 8-page decision on September 16, 2025. Nearly 3 weeks later, the defendant filed a petition pursuant to General Law 211 and filed a supplemental exhibit on Monday, October 6, 2025. The Commonwealth filed an opposition, and on October 15, 2025, the single justice, Dewar J., issued a decision finding that Judge McCarthy did not make an error of law or abuse her discretion. The defendant petitioned for review by the full bench on October 27, 2025. That's so funny because October 15th is my birthday and October 27th is my sister's birthday. That's so weird. Anyway, a little off subject. And the court ordered additional briefing on November 4th, 2025. The parties returned to the trial court on November 25, 2025 for scheduling of a trial date. The Commonwealth anticipates being ready for trial in January 2026. Statement of the facts. A. Statement of facts before J. McCarthy. Footnote 2. The facts set forth here are detailed in the police report that was part of the evidence submitted during the dangerousness hearing. Contrary to the defendant's claim, the facts of the underlying allegation are hotly contested. At approximately 6 p.m. on June 30th, 2025, Lieutenant Sean Daly, Officer Patrick Noonan, and Officer Timothy Houston of the North Andover Police Department responded to 125 Phillips Brook Road to serve the defendant with a restraining order. The defendant, a North Andover police officer, resided at 125 Phillips Brook Road with her friend with her fiance, Justin Ileon, and their 4-month-old infant. Earlier that day, Ileon had sought and was granted an abuse prevention order out of Essex Probate and Family Court. Ileon alleged that the defendant physically assaulted him over the previous weekend, hit him one time, I think, and that not that I'm saying that's okay, but still they're making it sound so much worse than it was, and that he was in fear of her and for the safety of his child. He stated that the defendant had assaulted him in the past and feared that the defendant would hurt herself and the child if he were to leave. Along with serving the order, the officers intended to remove the defendant's firearms from the residence and transfer custody of the child to Ileon. So imagine this. She just got reinstated and she was supposed to go back to work on July 4th. She just got her guns back. That day, Justin, had called her to tell her to meet him at a park with their son. And she waited there for 3 hours while he had somebody watching her and keeping an eye on her to let him know if she left, because he was in court filing for a restraining order. So he stood her up there so that he could go, so that he would know where she was, so that he can go file a restraining order. So she's losing her career, her fiance. They were supposed to get married in October, and her baby, all in one swoop. And they didn't provide a counselor or a mental health expert or anybody to be there for her when this all went down. It was complete bullshit. After arriving at her home, the officers informed the defendant about the restraining order, advising her that she was required to relinquish her firearms and give Ileon the baby. The defendant told the officers that her firearms were locked in a safe in the basement. Approximately 10 minutes after the officers arrived at the residence, they called Ileon to gather his belongings and take custody of the infant. In anticipation of Ileon taking the baby, the defendant gathered items, for example, clothing, diapers, bottles, from around the house. Officers Houston her between rooms. After gathering bottles and diapers on the first floor, the officers escorted the defendant to the second floor so that she could get baby clothes. I thought it was just Noonan that went up to the second floor with her. While they were on the second floor, Ileon and the defendant's mother arrived at the house. When the defendant heard Ileon, she asked Officer Houston to keep him away from her. To maintain order, Officer Houston left the defendant and Officer Noonan on the second floor and went to monitor Ileon as he gathered belongings in the basement. Lieutenant Daly remained on the... I thought it was Noonan that was on the second floor. Okay, on the first floor. Okay, sorry. Lieutenant Daly remained on the first floor with the defendant's mother. Ileon and Officer Houston minutes later... Lieutenant Daly remained on the first floor with the defendant's mother, Ileon, and Officer Houston. Minutes later, he heard Officer Noonan on the second floor yell, quote, "Kelsey, don't do it. Kelsey, don't do it," end quote, followed by 2 gunshots. He ran upstairs and rendered first aid to the defendant, who had been shot once in the abdomen, and requested an ambulance to the scene. She wasn't shot in the abdomen. She was shot in the chest, left chest. Lieutenant Daly observed a firearm where the defendant was lying and moved it to the bed. Officer Noonan explained that he was briefly alone with the defendant on the small second floor. The defendant was kneeling on the floor in her bedroom, folding laundry for the baby. While standing in the doorway, Officer Noonan observed the defendant face him, lunge behind the door, and reappear pointing a firearm. Okay, this I have an issue with. Lunge behind the door and reappear pointing a firearm directly at him. First of all, if you're kneeling on the floor, you're not going to be doing much lunging. How do you lunge when you're kneeling, okay? And second of all, remember when Melanie Little looked up the real estate listing for her house and we did the interior tour? There are no doors in this house. There is no bedroom door that she could have lunged behind. So no, she not only didn't lunge, she didn't go behind a door. There was no door. So he's lying. And reappear pointing a firearm directly at him. The defendant pulled the trigger and he heard a quote-unquote click, but no round fired. The defendant began to stand up as Officer Noonan pulled his firearm out of his holster. As the defendant attempted to rack her firearm to chamber a round, Officer Noonan gave several commands, including drop the gun and don't do it. Nobody heard him say drop the gun. That is not in any police report. Believing that she was trying to kill him, Officer Noonan fired once as the defendant continued trying to chamber a round. I thought he fired, didn't he say in his police report he fired twice? Because we were wondering where the first round went. Where did it go? Is it in the floor, the ceiling, what? Officer Noonan fired Officer Noonan fired a second round, striking the defendant. Where did it say the first one struck? It doesn't say. Okay. B. Superior Court 58A hearing. At the 58A hearing in Superior Court on August 28, 2025, the Commonwealth submitted the state police report detailing the above facts. The Commonwealth also submitted an affidavit filed in support of a 209A restraining order filed in the probate court by Ayalon on June 30th, 2025. The affidavit outlined that the defendant was heavily intoxicated and physical with others during an incident in Maine on or about June 28, 2025, which was described as the defendant's bachelorette party. I already read that one, right? Okay, so we have a footnote 3. This was Judge McCarthy's second time considering the question of dangerousness with respect to the defendant. Well, whoop-de-doo. As the 209A order was issued from the probate court, a judge found that there was a substantial likelihood of immediate danger or abuse to Ayalon. The materials submitted by the Commonwealth. Have you seen how small Kelsey Fitzsimmons is? And he's saying publicly that he's in fear of her. How embarrassing. What a complete pussy. I mean, are you... Wow. He should be ashamed of himself. Because if you see pictures of him and her together, he's at least a foot taller than her. He may not be big and buff, but he's way bigger than her. Whatever. The materials submitted by the Commonwealth also included written statements made by Ayalon and other people who were present during the incident in Maine on June 28th and the incident on June 30th. Through these statements, witnesses described... What witnesses on June 30th? Oh, wait. Never mind. That wasn't when she shot herself. Never mind. Sorry. Through these statements, witnesses described the defendant as intoxicated, drinking heavily, and engaging in aggressive behavior towards numerous individuals during the June 28th incident. The statements also reference prior similar behavior by the defendant. The defendant argued that she should not be found dangerous and is this not moving for you guys? Oh, Jesus. Just a second. Sorry. Yeah, it is. Okay. Sorry. My bad. Okay. Where was I? The defendant argued that she should not be found dangerous and moved that she be admitted to personal recognizance or reasonable bail under Section 57 of the bail statute. Defense counsel submitted reports from Dr. Nisavio, a doctor on the psychiatry service at Massachusetts General Hospital, and Dr. Zaitel, a licensed forensic psychologist. Based on the materials submitted by defense counsel, Dr. Nisavik opined that the defendant no longer met the Section 12 criteria being a harm to herself or others, and is appropriate for outpatient care once medically stabilized and discharged. Through their motion, defense counsel requested that the court issue appropriate orders in the interest of justice set forth above. Footnote 4. However, as Judge McCarthy noted, the defense did not submit any documentation regarding the defendant's physical medical condition as part of the dangerousness hearings. Not a single medical record or affidavit from a treating physician were submitted in either hearing related to the 58A District Court motion, nor the Superior Court hearing. That wasn't in question, that's why. And she didn't know she was going to have a hard time doing the deep breathing. She didn't know until she did it. After argument from the Commonwealth and defense, Judge McCarthy found that the defendant was a danger based on the above alleged facts, her history of mental illness, and the defendant's out-of-state record, including public intoxication and disruption. That was when she was 18, I think. I can't believe they're bringing that up. But recognizing the change in circumstance from the District Court 58A bail review, where the defendant was also charged with assault with intent to murder, Judge McCarthy found that there were conditions of release that would provide the necessary protection to the community. Scram testing is going to protect the community? Okay. GPS home confinement, residing with her mother and stepfather, compliance with mental health treatment, and abstaining from alcohol with scram testing. The defendant's release was stayed pending a satisfactory home review by probation. As part of their piecemeal litigation, wow, defense counsel filed a quote-unquote medical notice to the court on September 5th, 2025, which was simply a filing by defense counsel and was impounded by the court. The defendant finally filed a letter signed by a medical doctor on September 15th, 2025, after the defendant had been remanded to custody and after the defendant filed the motion to reconsider. The one-page letter summarized the defendant's injuries and supported the claim that deep breathing may be painful, but did not indicate that deep breathing would hinder the healing process. After reviewing the Carey reports of the residents of the defendant's proposed place of release, the court ordered a further hearing. On September 8, 2025, the court released the defendant according to the previously ordered conditions. But before the hearing even ended, the defendant sought an order to relieve her of the GPS device for the following day to attend a medical procedure. It wasn't a medical procedure, it was surgery that she needs. However, the defendant did not submit any evidence that the defendant could not wear a GPS device during the procedure. The court denied the request. 2 days later, on September 10, 2025, the defendant filed an quote-unquote emergency motion for immediate relief from the scram order, end quote. The defendant claimed that she was, quote, unable to do the testing without experiencing severe abdominal pain and dizziness, end quote, and claimed with no medical support that the breathing, quote, impairs healing of her broken ribs and punctured lung, end quote. Because breathing into the scram device was, quote, physically impossible, end quote. She didn't say it was physically impossible. She said it caused a lot of pain. The defendant could not, quote, comply with this order. The defense move that it be vacated, end quote. They are twisting the words so badly. It's infuriating. The motion was unsupported by any medical evidence, but attached an affidavit from the defendant and her mother and an email from the Assistant Chief Probation Officer, Jeff January. Judge McCarthy held a hearing the next day, September 11, 2025, and made abundantly clear her perspective on alcohol testing. When defense counsel framed the issue as, quote, a simple adjustment of terms, end quote, the court disagreed. Quote, I don't see it that way. I'm telling you it's not a simple adjustment. One of the reasons she was released and one of the reasons to ensure the safety of the community was for her to be alcohol-free. If she cannot do that or will not do that, that changes everything, end quote. That's what the judge said, and she said it a lot nastier than I did. Defense counsel argued that although the defendant could pass the test, it was only with quote-unquote difficulty. At the court's direction, P.O. January was sworn, and he described the defendant's performance on the SCRAM tests. Footnote 5. Judge McCarthy indicated that she was surprised that the testing was not random and that the defendant was apprised of a testing schedule because she didn't put it in her orders. He also observed that the defendant appeared to be, quote, in genuine pain, end quote, during the setup process, and for that reason did not believe that failures to complete scheduled tests were willful violations of probation. The court also accepted the defendant's SCRAM history as evidence. The Commonwealth presented no evidence, but reiterated, quote, how important that the Commonwealth's belief is, in light of the court releasing the defendant, that testing be done, end quote. That didn't make any sense. After confirming that the defense had nothing further to present, the court heard argument from defense counsel. He reiterated that the test was only possible, quote, with significant pain and dizziness and having to recover for several hours, end quote. He argued, quote, that there's other ways to do this. If the court wishes to have her tested for alcohol, lack of alcohol, that's completely fine with the defense. But just the means that's employed is kind of a torture device for her, end quote. Quote, cruel and unusual, end quote, punishment, and a potential Eighth Amendment violation. However, every time Timothy Bradel brings up anything about the Constitution, the judge blows a gasket. However, contrary to his assertion here, defense counsel did not offer any alternative methods of testing. The court took a recess before issuing a decision. I have reviewed everything again that's been submitted to me, and I will state for the record that Fitzsimmons has moved twice in a 3-day period to amend the blank her conditions of release. On either occasion, has she submitted any medical evidence to support her... On neither occasion has she submitted any medical evidence to support her claims. The imposition of conditions is the court's order, after careful consideration of the evidence, to fashion the least restrictive conditions that will reasonably assure the appearance of the defendant and the safety of all other persons in the community, pursuant to General Laws, Chapter 276, Section 58. Just days ago, the court concluded that the condition of remaining alcohol-free and submitting to SCRAM monitoring was necessary to ensure the safety of the community. After a thorough review of all of the arguments and submissions by the Commonwealth and Fitzsimmons, that conclusion remains unchanged regardless of Fitzsimmons' claimed physical limitations. Based on an affidavit submitted by Fitzsimmons' mother, the testimony of Assistant Chief Probation Officer Jeff January about his observations of Fitzsimmons' apparent pain during the SCRAM installation, and the representations of Fitzsimmons' counsel that it would be cruel and unusual punishment and torture to continue to require Fitzsimmons to comply with the condition of being monitored by SCRAM, the court concludes that Fitzsimmons cannot abide by the condition of being monitored by SCRAM. Without this condition, which ensures that she does not consume any alcohol, the court cannot assure the safety of Officer Noonan and all other persons in the community. Accordingly, the court's prior order of release is vacated, and Fitzsimmons is ordered to be held without bail pursuant to Mass General Laws, Chapter 276, Section 58A, and a written order will follow. And we have another footnote. Although the defendant disparages Judge McCarthy in his brief, it's a she, first of all, brief, and attempts to characterize her behavior as injudicious and short-tempered, the transcript reveals that she presented the defendant with every opportunity. Yeah, that's why you need to listen to the recording. Anybody can read the transcript and make it sound not so bad. C. Motion to reconsider. Judge McCarthy issued a written order on September 11, 2025, But before it was docketed, the defendant filed a motion to reconsider, asking the court to release the defendant and order alcohol urine screens at a private facility. The defendant supported the motion to reconsider with an attached email from P.O. January from September 10, 2025, in which he had responded that the only alternative to scram testing was urine screens at a probation vendor. In a 5-page written decision, Judge McCarthy denied the motion to reconsider, finding that, quote, there is nothing in the motion that was not known to the defendant or her counsel when this matter was last before the court on September 11, 2025. There has been no change in circumstances or newly discovered information that would warrant revising the court's decision pursuant to General Law 276, Section 58A, or mass criminal whatever. The court reasonably concluded that defendant's, quote, failure to transparently provide information related to her ability and willingness to abide by the conditions imposed despite 3 lengthy hearings is a manipulation of the court's efforts to fashion the least restrictive conditions of release. End quote. What a fucking bitch. Footnote, to present evidence and make argument. After a recess, she issued her ruling from the bench and concluded the hearing. It was defense counsel who interrupted the judge, yelled to the bench after the hearing was concluded, and had to be chastised by a court officer for swearing. Fuck off. Fuck all the way off. Are you kidding me? And what are you getting involved with that part for anyway? What the... Judge McCarthy noted the defendant's deliberate decision not to present the alternative urine testing through a private vendor through testimony of the probation officer. At the hearing on September 11th, the court gave the parties ample opportunity to present their arguments. Mr. January was present and testified under oath. For some reason, rather than bringing the alternative testing to the court's attention and inquiring about it with Mr. January during his testimony before the court, defense counsel at that time sought only an order completely relieving the defendant of the condition of release, her to submit to scram monitoring. That is a lie. That is a blatant lie. D. Petition for relief pursuant to General Law 211. On October 3rd, 2025, the defendant petitioned this court pursuant to General Law 211. The Commonwealth opposed, and on October 15, 2025, the single Justice Dewar found that Judge McCarthy did not abuse her discretion and commit an error of law. Footnote 7. Judge McCarthy also noted that the proposed alternative, which was not supported by testimony from the probation department, would significantly alter the home confinement condition. The alternate testing would also be a poor substitute for scram testing because it would not be conducted every day, and the defendant would know in the morning if she was going to be tested that day. Who cares? Oh my God. Contrary to the suggestion in the petition, the judge did not revoke the defendant's bail pursuant to General Law 276, rather pursuant to the last sentence of General Law 276-58A. Second part, on motion of the defendant, the court reconsidered the bail order and concluded that because of a change in circumstance that had arisen, the defendant's liability to comply without intense pain with in-home scram alcohol monitoring, a condition of release that the court viewed for reasons stated in the court's order as critical to reasonably assure the safety of another person and the community if the defendant were to be released on home confinement. No conditions would reasonably assure the safety of the named person and the community. As the Commonwealth notes, nothing prevents the defendant from requesting relief pursuant to the same provision if and when the defendant can make a showing that, quote, information exists that was not known at the time of the hearing or that there has been a change in circumstances, end quote. Jesus. I mean, it sounds like he went to school to learn how to defend the judge, right? That's what it sounds like to me. This fucking prosecutor. And that such information or change in circumstances has a material bearing on the issue of whether there are conditions of release that will reasonably assure the safety of any other person of the community. Rather than seek relief in the Superior Court as suggested by the single justice, the defendant filed a notice of appeal pursuant to SJC Rule 221 on October 20th, 2025, and the matter entered in this court on October 27th, 2025. The court ordered full briefing on November 4th, 2025. Footnote 8. 10 weeks have passed since the defendant was remanded to custody, and it is incredible to believe that her medical condition has not improved so that she would be able to breathe adequately into a scram device. Do you know how long it takes for broken ribs to heal? Like a year to completely heal. I had broken ribs, and every time I took a deep breath or coughed for almost a year or more after, I had significant pain. Not to mention she had a hole in her lung that was trying to heal into a scram device. But rather than file a motion to reconsider, as suggested by the Commonwealth in single justice, defense counsel chose to utilize the somewhat protracted appellate process, perhaps to garner additional publicity and sympathy for his client. What a douchebag. Argument. Judge McCarthy did not abuse her discretion or commit an error of law in finding the defendant dangerous and mandating conditions of release, where she appropriately considered the defendant's actions in pointing a loaded firearm at a fellow officer and pulling the trigger, coupled with an admitted history of mental illness and persistent alcohol abuse. Quote, when a party appeals from an adverse judgment by the single justice under General Law 211, this court reviews the single justice's order for clear error of law or abuse of discretion. Whereas here, the single justice did not exercise his discretion to this court focuses its attention on his legal ruling that the bail judge did not abuse his discretion. This court reviews this legal ruling independently to determine whether it is erroneous without giving deference to the single justice's decision. In effect, this means that this court must address the same legal issue presented to the single justice, whether the bail judge's decision to deny the defendant's bail request involved an abuse of discretion or error of law. Vasquez v. Commonwealth. Just 1 second, sorry. Vasquez versus Commonwealth, 481 Mass 747, 751, 2019. Internal citations omitted. However, where the quote, bail judge's decision involved an exercise of discretion, this court must accord it great deference, and this court will not overturn his decision for abuse of discretion because this court would have reached a different result, end quote. Applying same standard of review in the context of the 58A. Footnote 9. God, this is a long footnote. The defendants claim that the single justice was required to conduct a de novo review of the bail judge's determination is wrong, and the cases she cited do not support the claim. See Commonwealth v. Chisholm, 476 Mass. Because this is an appeal from the decision of the single justice of the county court under General Law 211, we must decide whether the single justice committed an error of law or abused her discretion in concluding that the single justice of the appeals court committed an error of law and abused his discretion in affirming the judge's denial of the motion to impound. And Comesso v. Commonwealth 369, Mass 368, 373 to 374, 1975. Recognizing that while the single justice has the power to consider the matter anew, in the ordinary case, it is the practice of the single justice to review the matter only with reference to errors of law. And requiring de novo review by a single justice would lead to the absurd and unworkable result of permitting every 58A decision to be heard anew by the single justice. But in any event, the defendant did not submit the exhibits considered by Judge McCarthy in support of the 58A to the single justice. Even more egregiously, she failed to include the exhibits in her record appendix to the full bench, but claims, quote, the record appendix contains everything filed for the trial court's consideration, end quote, which is obviously false. What a piece of shit, the way he's talking about her. I mean, what the hell? What got into him? Judge McCarthy appropriately weighed the necessary factors when finding the defendant dangerous. The government has a paramount interest in protecting its citizens. Okay, they act like she is some kind of terrorist or something, you know? Which is served by the pretrial detention regime. Specifically, the dangerousness statute, quote, seeks systematically to identify those who may present a danger to society and, wow, and to incapacitate them before that danger may be realized, end quote. A measure, quote, a measure intended to protect the public from the violent acts of a dangerous individual, end quote. They talk about her like she is like an assassin. Pre-trial detention is warranted if the judge finds, quote, by clear and convincing evidence that no conditions of release will reasonably assure the safety of any other person in the community, end quote. The words he's using are so like angry, like you know, the egregious and all. I mean, what the hell? The court's decision to obtain an individual 58A this discretion or in the full court review is more strictly limited to errors of law. An abuse of discretion occurs when a judge, quote, made a clear error of judgment in weighing the factors relevant to the decision such that the decision falls outside the range of reasonable alternatives, end quote. And that's what happened. The finding of dangerousness. Here, no error of law or abuse of discretion has been established. As an initial matter, Judge McCarthy reasonably concluded that the defendant was a danger on August 28, 2025, with respect to the facts of the charged offenses. From the outset, the defendant lied about the location of her guns, an apparent attempt to lull the officers into a false sense of security. She then pointed a loaded firearm at a fellow police officer, pulled the trigger, and repeatedly attempted to reload the gun. No, she didn't. She did it one time. To load more bullets into the weapon when the first shot did not fire. The nature of the offense, combined with the defendant's recent history of violence against the father of her child and threats to the safety of her own child, further support the determination that the defendant is a danger to the community. As Judge McCarthy noted, a probate court judge found that there was a substantial likelihood of immediate danger or abuse to the child's father. Fuck off. Furthermore, Judge McCarthy recognized that the defendant had a history of mental illness, Ayalon wrote that she had been recently, quote, sectioned by Lawrence General Hospital, end quote, and the defense acknowledged a history of postpartum depression and suicidality. Postpartum psychosis, not just depression. And her doctor cleared her of that. Among factors the court may consider under 58A are, quote, the nature and seriousness of the danger posed to any person or the community that would result from the person's release, and the defendant's history of mental illness. You knew that was going to be used against her. The defendant appears to argue that she is entitled to deferential treatment because she was, quote, a sworn law enforcement officer from 2 different Essex County agencies. She never said that. She never, ever said she deserved deferential treatment, and has passed many hurdles to becoming a police officer. However, Judge McCarthy was not required to give the former police officer special treatment where the facts suggest that rather than acting swiftly and without compassion, 3 of her colleagues gave the defendant the benefit of the doubt when they entered her home and asked where the guns were located. The defendant betrayed her fellow officers and lied to them when she said they were in the basement. Given these circumstances, Judge McCarthy properly found, quote, by clear and convincing evidence that no conditions of release will reasonably assure the safety of any other person or the community, end quote. Constitutional attack rejected as to 58A, detention predicated on defendant's history of threats in the context of evidence of his psychiatric hospitalizations. It's her psychiatric hospitalizations. Drug dependency and suicidability. Drug dependency, where's that? Oh, that's from the Mendoza case reference. The Scram condition of release. Quote, rather than hold the defendant in custody, the court sought to fashion the least restrictive conditions of release that would reasonably assure her appearance and the safety of all other persons in the community as required, end quote. Okay, she's so dangerous, but she's not that dangerous that she can't be released as long as she's on Scram testing. Are you fucking kidding me? Either she's dangerous or not. Scram testing is not going to do a goddamn thing if she is that dangerous. I'm telling you right now, it's not. And to think anything else is irresponsible of this judge. If that's how she releases people on bail, then... Most importantly here, the court ordered the defendant to submit to Scram monitoring, despite the defendant's cavalier approach to removal of the condition and her persistent view that, quote, the incident had nothing whatsoever to do with alcohol, end quote, which it didn't. Judge McCarthy justifiably found that, quote, monitoring the defendant for alcohol use with a Scram device was critical to the court's decision to release her on conditions, end quote. The precipitating events over the weekend of June 28, 2025, that caused Ayalon to obtain a restraining order were fueled by alcohol. He reported that, so he didn't drink? Nobody else drank that weekend but her? She's the only one that drank at the bachelorette weekend? Bachelorette weekend? Bullshit. He reported that the defendant was, quote, heavily intoxicated, end quote, and that she refused his request to stop drinking. She's at her bachelorette party. The defendant's childhood friend corroborated that the defendant had been drinking on June 28th and that her actions that night were erratic and violent. The friend further stated that the defendant has, quote, struggled with mental health issues, aggression, and alcohol abuse previously. I'd like to see proof of that. Finally, the defendant even has out-of-state criminal charges from 2018 that reflect issues with alcohol, intoxicated and disruptive. She was a little rowdy. Big deal. Footnote 10. The Commonwealth could not locate imagine that, could not locate a copy of the defendant's Carry 3 in the court file, but the record reflects that Judge McCarthy had a copy during the hearing. Sure, she did. The copy included in the supplemental record appendix at page 5354 accurately depicts what was before the court on August 28, 2025, and was included in the Commonwealth's submission to the single justice. Oh my gosh. They're just going to throw that in her face every chance they get, right? Where alcohol is so clearly intertwined with the defendant's ability to control her behavior, the court's insistence on scram monitoring was eminently reasonable. Commonwealth not required to demonstrate nexus between dangerousness of charged offenses and danger that accused might have presented if left at large in order to justify pretrial detention. The motion to remove the scram condition. The defendant's motion to relieve her from the scram requirement triggered reconsideration by the court, not revocation pursuant to 58B as claimed by the defendant. Footnote 11. Judge McCarthy specifically rendered her decision pursuant to 58A, and the single justice also concluded that the defendant's detention was based on reconsideration, not revocation. Didn't she use the word revoke? I thought she did. Section 58A specifically permits reconsideration of a prior detention order where there has been a material change in circumstances. What's the material change in circumstances? That she's in pain? Sorry. The hearing may be reopened by the judge at any time before trial. If the judge finds that information exists that was not known at the time of the hearing, or that there has been a change in circumstances, and that such information or change in circumstances has a material bearing on the issue of whether there are conditions of release that will reasonably assure the safety of the community, end quote. On September 11, 2025, after learning about the intense pain caused by the process of the scram testing, Judge McCarthy became justifiably concerned because she did not intend the condition to be punitive. Yeah, right. However, quote, ordering the defendant to remain alcohol-free and monitoring her for alcohol use with a scram device was critical to the court's decision, end quote. Given the evidence supporting the imposition of the scram device in the first place, as noted above, Judge McCarthy was well within her discretion to conclude that she could not assure the safety of the community if the defendant's sobriety was not reliably monitored. The defendant's claims that Judge McCarthy should be aware of alternative testing options is without evidence in the record. I don't know what that is. Moreover, Judge McCarthy's concern that the defendant manipulated the process is justifiable. Defense counsel failed to raise any concerns regarding the defendant's ability to breathe deeply in 2 prior hearings and persistently failed to introduce medical evidence to support her claims. Additionally, there is no explanation for defense counsel's failure to question P.O. January about his email from the night before regarding urine testing, or to mention the possibility to the court when given ample opportunity. Other than that, it was a reasoned tactical decision by a seasoned defense attorney seeking to release the defendant from alcohol testing entirely. Wow. Footnote 12. And in any event, Judge McCarthy appeared disinclined to consider the urine testing option where it would require release from home confinement. Moreover, the testing seems an unreliable means of confirming sobriety when the individual is informed in the morning that they will not be tested that day. There would be no disincentive not to drink that day when they are aware that they will not be subject to testing. So don't tell her. That's an easy enough fix. I don't get that at all. So where was I now? I lost my place. Sorry, guys. Okay. A motion to suppress is not a dry run or a dress rehearsal to come back once an adverse ruling is obtained to try to and do it all over again. The claim related to the Americans with Disabilities Act is likewise baseless. The defendant cites no federal or state case addressing the intersection of the ADA and 58A. It appears to be an open question whether the ADA applies to dangerousness hearings. Then it says that one of the cases applies to disabled prisoners and another case applies to parole proceedings. Quote, we must accord substantial deference to the professional judgment of prison administrators who bear a significant responsibility for defining the legitimate goals of a correction system and for determining the most appropriate means to accomplish them, end quote. Moreover, contrary to the claim that the defendant has, quote, conclusively demonstrated disability, end quote, there is a dearth of medical evidence suggesting that the defendant's condition ever qualified her as a disabled person, or that the act of breathing deeply enough to submit a sample for the SCRAM device was akin to, quote, an activity of daily living, end quote. Disability is defined as a physical implement that substantially limits one or more of the major life activities of such individual. Footnote 13, the only medical evidence in the case was a treating physician's letter. It was not a treating physician, it was her trauma surgeon. Thank you very much. And do you know how hard it is to get a letter or anything from a trauma surgeon? They're so busy, they don't have time for that shit. Letter from September 15, 2025, opining that a rib fracture, quote, can cause pain that may persist for several months after the injury, end quote, or that retained bullet fragments, quote, could cause chronic pain that can be exacerbated by movement, such as deep breathing, end quote. The defendants claim that she, quote, has severely diminished lung reported in the record. Well, I am a respiratory therapist, and I am here to tell you that is definitely what is happening. She definitely has a diminished lung capacity. So, fuck off. Fuck all the way off. And finally, excuse my language, I'm sorry. And finally, as noted above, the defendant strategically elected not to present evidence of any reasonable accommodation that would obtain the same objective as the SCRAM device. Just 1 second, okay? Okay, sorry about that. Let's see. Let's go back now. Sorry. Okay. And finally, as noted above, the defendant strategically elected not to present evidence of any reasonable accommodation that would obtain the same objective as the Scram device. In sum, Judge McCarthy acted prudently and deliberately in considering the Commonwealth's request for detention. She considered the evidence presented and made multiple supportable oral and written findings, resorting to detention as a last resort. Bullshit. I didn't hear her mention anything else. The defendant has not demonstrated that she made an error of law or abused her discretion. Footnote 14. Oh my God, this is making me so angry to listen to this. The Commonwealth reiterates that the defendant may request relief when the defendant is healed and able to perform the Scram test without pain, or if a quote-unquote new testing alternative becomes available. Quote, judges have considerable discretion to permit a pretrial motion that has been heard and denied to be... All right, well... Conclusion. For the foregoing reasons, the court should affirm the single justice's finding that the motion judge did not abuse her discretion or commit an error of law. For the Commonwealth, Paul F. Tucker, District Attorney. What does this all say? Okay. The Commonwealth may move, based on dangerousness, for an order of pretrial detention or release on conditions for a felony offense that has as an element of the offense the use, attempted use, or threatened use of physical force against the person of another or any other felony that, by its nature, involves a substantial risk that physical force against the person of another may result, including the crimes of burglary and arson, whether or not a person has been placed at risk thereof, or a violation of an order pursuant to. I don't know what all that means. What is all this? Upon the appearance before a superior court or district court judge of an individual charged with an offense listed in subsection 1, and upon the motion of the Commonwealth, the judicial officer shall hold a hearing pursuant to subsection 4, issue an order that pending trial the individual shall either be released on personal recognizance without safety, released on conditions of release as set forth herein, or detained under subsection. Yeah, but the thing is she would only get, I don't even know what, I think the max of what she could get is like 3 years or something like that for the charge that she's being charged with. And they're treating it like she's on a death penalty case, you know? If the judicial officer determines that personal recognizance will not reasonably assure the appearance of the person as required or will endanger the safety of any other person or the community, such judicial officer shall order the pretrial release of the person, A, subject to the condition that the person not commit a federal, state, or local crime during the period of release, and B, subject to the least restrictive further condition or combination of conditions that such judicial officer determines will reasonably assure the appearance of the person as required and the safety of any other person in the community that the person I. Remain in the custody of a designated person who agrees to assume supervision and to report any violation of a release condition to the court. If the undersigned person is able reasonably to assure the judicial officer that the person will appear as required and will not pose a danger to the safety of any other person or the community. Maintain employment, or if unemployed, actively seek employment. Oh, yeah, well, you give me a job and just FYI, I might have to quit in a year because I might be sentenced to prison time. Okay. Maintain or commence an educational program. Abide by specified restrictions on personal associations, place of abode, or travel. Avoid all contact with an alleged victim of the crime and with any potential witness or witnesses who may testify concerning the offense. Report on a regular basis to a designated law enforcement agency, pretrial service agency, or other agency. Comply with a specified curfew. Refrain from possessing a firearm, destructive device, or other dangerous weapon. Refrain from excessive use of alcohol or any use of narcotic drug or other controlled substance without a prescription by a licensed medical practitioner. Undergo available medical, psychological, or psychiatric treatment, including treatment for drug or alcohol dependency, and remain in a specified institution if required for that purpose. Next, they're going to say they want her to complete alcohol treatment. Watch. That's going to be like a one of her bail conditions. Watch. Execute a bail bond with solvent sureties who will execute an agreement to forfeit in such amount as is reasonably necessary to assure appearance of the person as required, and shall provide the court with information regarding the value of the assets and liabilities of the surety, if other than an approved surety, and the nature and extent of encumbrances against the surety's property, such surety shall have a net worth which shall have sufficient unencumbered value to pay the amount of the bail bond. I don't know what all this is. Return to custody for specified hours following release for employment, schooling, or other limited purposes, and satisfy any other condition that is reasonably necessary to assure the appearance of the person as required and to assure the safety of any other person and the community. The judicial officer may not impose a financial condition that results in the pretrial detention of the person. The judicial officer may at any time amend the order to impose additional or different conditions of release. Participation in a community corrections program pursuant to Chapter 211F may be ordered by the court or as a condition of release, provided, however, that the defendant shall consent to such participation. If after a hearing pursuant to the provisions of subsection 4, the district or superior court justice finds by clear and convincing evidence that no conditions of release will reasonably assure the safety of any other person or the community, said justice shall order the detention of the person prior to trial. A person detained under this subsection shall be brought to trial as soon as reasonably possible, but in absence of good cause, the person so held shall not be detained for a period exceeding 120 days by the district court or for a period exceeding 180 days by the superior court, excluding any period of delay as defined in Massachusetts Rules of Criminal Procedure Rule. A justice may not impose a financial condition under this section that results in the pretrial detention of the person. Nothing in this section shall be interpreted as limiting the imposition of a financial condition upon the person to reasonably assure his appearance before the courts. When a person is held under arrest for an offense listed in subsection 1, and upon a motion by the Commonwealth, the judge shall hold a hearing to determine whether conditions of release will reasonably assure the safety of any other person or the community. The hearing shall be held immediately upon the person's first appearance before the court, unless that person or the attorney for the Commonwealth seeks a continuance. Except for good cause, a continuance on motion of the person may not exceed 7 days, and a continuance on motion of the attorney for the Commonwealth may not exceed 3 business days. During a continuance, the individual shall be detained upon a showing that there existed probable cause to arrest the person. At the hearing, such person shall have the right to be represented by counsel, and if financially unable to retain adequate representation, to have counsel appointed. The person shall be afforded an opportunity to cross-examine witnesses who appear at the hearing and to present information. Prior to the summons of an alleged victim or a member of the alleged victim's family to appear as a witness at the hearing, the person shall demonstrate to the court a good faith basis for the person's reasonable belief that the testimony from the witness will be material and relevant to support a conclusion that there are conditions of release that will reasonably assure the safety of any other person or the community. The rules concerning admissibility of evidence in criminal trials shall not apply to the presentation and consideration of information at the hearing, and the judge shall consider hearsay contained in a police report or the statement of an alleged victim or witness. The facts the judge uses to support findings pursuant to subsection 3 that no conditions will reasonably assure the safety of any other person or the community shall be supported by clear and convincing evidence. In a detention order issued pursuant to the provisions of said subsection 3, the judge shall include written findings of fact and a written statement of the reasons for the detention. Direct that the person be committed to custody or confinement in a corrections facility separate to the extent practicable from persons awaiting or serving sentence or being held in custody pending appeal, and direct that the person be afforded reasonable opportunity for private consultation with their counsel. The person may be detained pending completion of the hearing. The hearing may be reopened by the judge at any time before trial or upon a motion of the Commonwealth or the person detained. If the judge finds that information exists that was not known at the time of the hearing, or that there has been a change in circumstances, and that such information or change in circumstances has a material bearing on the issue of whether there are conditions of release that will reasonably assure the safety of any other person or the community. It is determination as to whether there are conditions of release that will reasonably assure the safety of any other individual or the community. Said justice shall, on the basis of any information which he can reasonably obtain, rule into account the nature and evident and seriousness of the danger posed to any person or the community that would result by the person's release, the nature and circumstances of the offense charged, the potential penalty the person faces, the person's family ties, employment record and history of mental illness, his reputation, the risk that the person will obstruct or attempt to obstruct justice or threaten injure, or intimidate, or attempt to threaten, injure, or intimidate a prospective witness or juror, has record of convictions, if any illegal drug distribution or present drug dependency, whether the person is on bail pending adjudication of a prior charge, whether the acts alleged involve abuse as defined in Section 1 of Chapter 209A, or violation of a temporary or permanent order issued pursuant to Section 18 or 34B of Chapter 208, Section 32 of Chapter 209. Whether the person has any history of orders issued against him pursuant to the aforesaid sections, whether he is on probation, parole, or other release pending completion of sentence for any conviction, and whether he is on release pending sentence or appeal of any conviction provided. However, that if the person who has attained the age of 18 years is held under arrest for a violation of an order issued pursuant to, and then the chapters. Wow. Or any act that would constitute abuse as defined in Section 1 of said chapter of the sections, said justice shall make a written determination as to the considerations required by this subsection, which shall be filed in the domestic violence record keeping system. Wow, that's a lot to say. Nothing in this section shall be construed as modifying the limiting presumption of innocence. Okay. God, how much more of this do I have? This is crazy. A person aggrieved by the denial of a district court justice to admit him to bail on his personal recognizance, with or without surety, may petition the Superior Court for review of the order of the recognizance, and the justice of the district court shall thereupon immediately notify such person of his right to file petition for review in the Superior Court. When a petition for review is filed in the district court or with the detaining authority subsequent to petitioner's district court appearance, the clerk of the district court or the detaining authority, as the case may be, shall immediately notify by telephone the clerk and probation officer of the district court, the district attorney for the district in which the district court is located, the prosecuting officer, the petitioner's counsel, if any, and the clerk of courts of the county in which the petition is to be transmitted. The clerk of the district court, upon the filing of a petition for review, either in the district court or with the detaining authority, shall forthwith transmit the petition for review, a copy of the complaint and the record of the court, including the appearance of the attorney, if any, is entered, and a summary of the court's reasons for denying the release of the defendant on his personal recognizance, with or without surety, to the Superior Court of the county in which the district court is located. If justice thereof is thus sitting, or to the Superior Court of the nearest county in which a justice is then sitting, the probation officer of the district court shall transmit forthwith to the probation officer of the Superior Court copies of all records of the probation office of said district court pertaining to the petitioner, including the petitioner's record of prior convictions, if any, as currently verified by inquiry of the Commissioner of Probation. The district court or the detaining authority, as the case may be, shall cause any petitioner in its custody to be brought before the said Superior Court within 2 business days of the petition having been filed. The district court is authorized to order any officer authorized to execute criminal process to transfer the petitioner and any papers herein above described from the district court or the detaining authority to the Superior Court, and to coordinate the transfer of the petitioner and the papers by such officer. The petition for review shall constitute authority in the person or officer having custody of the petitioner to transport the petitioner to said Superior Court without the issuance of any writ or other legal process, provided, however, that any district or Superior Court is authorized to issue a writ of habeas corpus for the appearance forthwith of the petitioner before the Superior Court. Jesus. The Superior Court shall, in accordance with the standards set forth in Section 58A, hear the petition for review under Section 58A as speedily as practicable, and in any event within 5 business days of the filing of the petition. The Justice of the Superior Court hearing the review may consider the record below, which the Commonwealth and the person may supplement. The Justice of the Superior Court may, after a hearing on the petition for review, order that the petitioner be released on bail on his own personal recognizance without your discretion to reasonably assure the effective administration of justice. Make any other order of bail or recognizance, or remand the petitioner in accordance with the terms of the process by which he was ordered committed by the district court. If after a hearing under subsection 4, detention under subsection 3 is ordered, or pretrial release subject to conditions under subsection 2 is ordered, then the clerk shall immediately notify the probation officer of the order, and the order of detention under subsection 2 or order of pretrial release subject to conditions under subsection 2 shall be recorded in the defendant's criminal record as compiled by the Commissioner of Probation under Section 110 and the Domestic Violence Record Keeping System. Jesus. I, Marina Moriarty, counsel for the Commonwealth, hereby certify that this brief complies with the rules of court that pertain to the filing of briefs and appendices, including but not limited to Mass R App Addendum. Compliance with the applicable length limit of Rule 20 was ascertained as follows. The brief uses Courier new font in 12 point, which contains 10 characters per inch. The number of non-excluded pages is 30. Certificate of service, okay. So, what do you think about that? God, that was long. So, yeah. So anyway, did you hear about the new DA candidate for Norfolk County? He's got an AJ Alan Jackson vibe, and he seems very ambitious. He quit. He was a subordinate to Josh Levy of the U.S. Attorney's Office, and he helped Josh Levy investigate the investigation of John O'Keefe's murder. And his name is Adam Deitch. And he quit his job at the U.S. Attorney's Office 10 days, about 2 weeks ago, and moved to Quincy, Massachusetts, which is where Meatball Morrissey resides, I believe, and to establish residency. And so he gave up a paycheck. He gave up a guaranteed paycheck to move to Quincy, Massachusetts, to run for Norfolk County DA. and he doesn't even know if he's going to win. So he quit a very well paying job and a guaranteed paycheck to take a leap of faith to run for Norfolk County DA. And if he doesn't win, it's like, what do I do? I left that awesome job and now I don't have an income. But that's how ambitious he is and how bad he wants to make change in Norfolk County. It's insane, and I think he'll do it. Let me see if I can find his campaign video. See if this is it. Nope, is that the video? I want to see the video. Okay, I'm determined to find the video because I'm sick of not being able to find the videos when I tell you I'm going to show you something. So, how long is this one? All the videos they keep coming up with are like 59 minutes long. You know, it's crazy. Let me see if this is it. Okay, that one's unavailable. Okay, great. Just 1 second. Nope, that's not it. God. Campaign video. Okay, let me see. Is this it? That's my dog. Sorry about that. Let's see if I can find the video. Let me see. That's not it. Adam Deitch declares run for meet Adam Deitch for DA, Federal Prosecutor Program Read. Why can't I find it? It's crazy. I don't know why. Or videos. That's gonna piss me off is what it's gonna do, you know? Every one I find is 59 minutes long. I don't get it. And of course all the douchebags on Twitter are attacking him already. He didn't announce he wasn't a candidate for 5 minutes before they started fucking attacking him on Twitter. They're such douche trolls, you know, but I don't think he's intimidated by them in the least bit. So let's see if I can find his stupid video. I mean, not stupid video, but if I can find the video, I can never find anything. I played it today, as a matter of fact, so it should be in my history. Let me look at my history. I don't see it now. What the heck? I should have just saved it so that I would have it ready to go, but I didn't think it would be this hard to find again. Let's see, nope. Okay, so let's go here. It's gotta be here. If not, we'll just play the news footage of it, which is what I'm gonna have to do apparently. So let's do Boston. But he talks about all the corruption and he's not afraid to mention the names and stuff of the corruption that he's talking about. He's not afraid to go at Morrissey and the McAlberts and whoever. He's facing them head on. He's not intimidated by him in the least bit. So let me share my screen. Okay. And make it bigger for you. I guess this is an article. It's not going to be a video. Nope, there's no video here, so I don't know. I don't know. Daughters declares. Okay, I think this is it. Let's see if it'll let me play it. It's taking its time. Come on. That's Morrissey's hostage video. Why are they saying that that's the video for Adam Deitch? It is not. Oh my God. Okay, well, let's move on to something else then, because I can't find the video and it's just going to piss me off. Okay, in regards to Karen Read and the McAlberts, supposedly the McAlberts and Higgins are eyeing defamation claims against Read and Turtle Boy. So let's read about this, shall we? Okay, let me share my screen with you. Share screen. Share. Okay. And then I'll expand it for you so it's bigger. Okay, Karen Read case. Alberts, McCabe's, Higgins eyeing defamation claims against Read and Turtle Boy. The witnesses from Read's high-profile murder case are denouncing her cover-up claims as a, quote, vile work of fiction, end quote, by Abby Patkin on November 17th. Still hounded by conspiracy theories months after Karen Read's acquittal, several witnesses from the high-profile murder case are denouncing Read's cover-up claims as a, quote, vile work of fiction, end quote. The outlandish frame job allegations were part of Read's scheme to defame and wrongly malign prosecution witnesses and evade responsibility for the death of her boyfriend, John O'Keefe. Lawyers for Brian and Nicole Albert, Jennifer and Matthew McCabe, and Brian Higgins argue in a new brief recently served on Read's legal team. All 5 witnesses attended an ill-fated after-party at the Alberts home in Canton, where O'Keefe's badly wounded body was found in the snow on January 29, 2022. Prosecutors alleged Read drunkenly backed her SUV into O'Keefe while dropping him off at the gathering, but she claimed investigators and after-party guests conspired to frame her. In June, a jury found Read not guilty of her most serious charges, convicting her only on a drunk driving misdemeanor. However, Read's legal saga is far from over. She still faces a wrongful death lawsuit from O'Keefe's parents O'Keefe's relatives, who maintained Reed was to blame for killing the Boston police officer. During a September hearing in the civil case, Reed's lawyers announced her plans to bring legal action against several witnesses and Massachusetts State Police investigators, further complicating the proceedings. Reed is seeking to combine her conspiracy and civil rights claims with the wrongful death suit for efficiency's sake, but a judge has yet to rule on the request. The Alberts, McCabe's, and Higgins are asking that Reed's motion be denied and her claims filed in a separate case. The Commonwealth witnesses vigorously dispute defendant Reed's allegations and will defend against these false claims, their lawyers explained. They said that their defense will include motions to dismiss, a potential request to move the claims to federal court, and counterclaims against both Reed and Turtle Boy blogger Aidan Carney for defamation and other torts that they have committed individually and in concert. A staunch supporter of Reed's innocence, Carney racked up several criminal charges after he was accused of intimidating witnesses in the case, including the Alberts and McCabe's. Authorities later alleged Reed leaked non-public information to Carney, though she was never charged with witness intimidation. Meanwhile, Carney maintains his actions were protected free speech. Lawyers for the Alberts, McCabe's, and Higgins said they had, quote, planned to seek justice in a separate action, end quote, over allegations that Reed and Carney, quote, injured, end quote, them through a myriad false statements. Combining those defamation claims with Reed's conspiracy claims and the O'Keefe's wrongful death suit is procedurally improper at this stage and will make for a much more sprawling case, the lawyers argue. Reached for comment on the potential defamation claims, Reed defense attorney Damon Seligson said via email, "Truth is an absolute defense to a claim of defamation, and we will defend Karen Reed vigorously against such baseless claims." Carney said in an email he has not been served by anyone involved in Reed's case. He cited just 1 second. Sorry about that. Carney said in an email he has not been served by anyone involved in Reed's case. He cited Jennifer McCabe's heavily debated Haas-Long to dying cold Google search and testimony from other witnesses in Reed's criminal trial, including defense crash reconstruction experts who said O'Keefe's injuries were inconsistent with having been struck by Reed's SUV, and a defense dog bite expert who opined O'Keefe had been wounded in a dog attack. Carney also pointed to several witnesses who denied seeing O'Keefe's body on the Alberts' front lawn early in the morning of January 29th, a group that included Higgins and the McCabe's. Given that evidence, he alleged the only logical conclusion a reasonable person could reach is what I have been saying for the last year. The people inside Brian Albert's house murdered John O'Keefe. The only reason they have not been arrested or treated as suspects is due to the corruption and incompetence of the Canton and state police, many of whom had direct ties to the Albert family, Carney wrote. Pointing out these facts is not defamation. They are free to sue me and bring this to trial, as I would be more than happy to keep their crimes in the public eye as much as possible and to explain these facts to a jury and let them decide who they think killed John O'Keefe. Ooh! Nobody absent from the opposition brief is Brian. Sorry. Notably absent from the opposition brief is Brian and Nicole Albert's nephew, Colin Albert, who was also present at 34 Fairview Road that night, the night John O'Keefe died. While Reed previously sought to implicate Colin Albert in her third-party culprit theory, she has not named him in her civil conspiracy claims. The wrongful deaths lawsuit is due back in court Friday. Well, yeah, because Judge Cannoni wouldn't let them mention Colin's name, remember? In the second trial. So, it's like, why bring him up? So, anyway, I believe that is all I have to go over today. And hopefully this live is better than the last few. But I hope to see you all again soon. I hope you enjoyed this video. Like and subscribe. And I will see you in my next stream. Be safe. Thanks again. Bye.